Greetings, Doctor. Today I will be presenting on definition of confession under the police custody in Malaysia. There are two limbs to it. One of it is confession and another limb is police custody. In discussing the definition of confession, the definition for it is confined under Section 17, Subsection 2 of the Evidence Act 1950, which is an admission made at any time by a person accused of an offense, stating or suggesting the inference that he committed that offense. As for a confession to be admissible, it must be made voluntary with the rules of admissibility. In the case of Lemonade against Public Prosecutor 1965, the court made a ruling that a mixed statement can still be admitted as a confession if taken as a whole, if it supports the inference that the accused committed the offense. And the classification of confession we can see in the decided case of Liang Wenheng against the public prosecutor, which is a 2014 case. The essence laid out in this case was that the admissions are not confession, but all confessions are admission, which the court set forth in its judgment. In discussing the confession made to a police officer, the confession will be admissible under Section 21 of the Evidence Act 1950, which will be read together with other provisions such as Criminal Procedure Act (CPC) and Dangerous Drug Act 1952. This was established in R against Wong Ah King, which is a 1935 case, where all confessions are relevant and can be proof against the maker unless it is excluded by sections in the Evidence Act. Moving on to the next slide, we will now discussing the definition of police custody. As for the definition of police custody, according to the Collins Online Dictionary, police custody means being kept in somewhere secure under the supervision of police officers. In R against Leicester, which is an 1895 case, the court ruled that the confession was irrelevant because the accused was still in custody, disregarding the temporary absence of the policeman. The gist of police custody is that it is sufficient if the police are capable of curtailing the liberty of the person concerned. To further deepen the understanding towards this, we can also look to the case of Sambu against Rex, which is a 1947 case, where it was held that the accused statement to the police officer was improperly admitted, contrary to Section 26 of the Act, as the confession was made in custody. As a whole, in conclusion, confession must be made voluntary, and the element of oppression and influence should not influence the confession. Thank you, Doctor.
Greetings and good day. I be to Dr. Rama. I shall continue the presentation under the subtopic Relevancy and Admissibility of Confession under Police Custody in Malaysia. We shall now first look into the Section 25 under the Evidence Act 1950, which stated that any confession made to the police officer under the rank of inspector is not admissible before the court. However, the exception is if the confession made to the police officer which is higher than the rank of inspector, it can be admissible as an evidence. Now, under the case of Yi Yameng against PP in the year 1972, in order to render the confession admissible, there must be evidence to show that the officer to whom the confession was made was not below the rank of inspector. Now, what is the meaning of police officer? In the case of R and against Wong Ah Kin, when ordinance says police officer, it must mean police officer. It cannot extend it to an act or exercising powers analogous to a police officer. And in the case of Chua Biao Huat against the PP, a customs officer is not a police officer within the meaning of Section 25 of the evident ordinance. The next section that I will explain is on the Section 26 of the Evidence Act 1950. Okay, Section 26 provided that the confession made by the accused while in custody of police officer not to be proved against him unless it is made in the immediate presence of a session court judge or magistrate. Confession stated under Section 26 not necessarily be made to a police officer. The main condition here is that it is being made under police custody be it to the police officer of all rank or to that person. And what will happen if the counsel to the accused fail to object for such admissible evidence under Section 26? The court stated in the case of Pakiam against PP that inadmissible evidence does not become admissible by reason of the failure of counsel to object, and appellate court must disregard all such evidence. If this situation happens and the conviction was made by inadmissible evidence, it will depend now whether there was other evidence to justify a conviction. I will further explain on Section 27 of the Evidence Act 1950. Now, Section 27 of the Evidence Act 1950, it actually helps as an exception to the law of confession under Section 24, 25 and 36 of the Evidence Act 1950. Under this section, the general rule is that the statement made by a person while in custody of the police officer is admissible as long as it strictly complies with the conditions stated under this section, and it does not matter whether it amounts to a confession or not. And if only the confession is not admissible, then the prosecution can rely on Section 27 to admit at least a part of the accused statement. What is the conditions under this section that must be complied with? Now, the first one is the information must have been received from a person accused of an offence, and such person must have been in the custody of a police officer. And the third one, a fact must have been deposed to as having been discovered in consequence of such information. And lastly, the information relates distinctly to the fact thereby discovered may be proved. My fellow colleagues will further explain on the relevancy and admissibility of confession under police custody in UK and also in India.
Greeting, Doctor. For my part, I will further explain Section 24 to 27 of the Indian Evidence Act in order to understand its position in India. So in Section 24, it rejects the admissibility of the confession in a criminal proceeding which appear to be the result of inducement or threat. This principle was derived from the case of Tajuk and State of Maharashtra, in which the Supreme Court observed that if a confession to police were allowed as proof in evidence, the police would torture the accused and force him to confess to a crime which he might have not committed. Next, in Section 25, it provided that no confession made to a police officer shall be proof as against a person accused of any offence. The apex court opined that the purpose of restriction imposed under Section 25 is to protect the person accused of a crime from third-degree treatment and to also ensure a proper investigation of the crime can be made to bring the real culprit to the judgment. And this was supported by the case of Queen Empress and Babu Lal, in which it observed that the objective rule is to prevent the practice of torture and oppression by police officers for the purpose of extorting confession and securing conviction. An exception to this section can be found under the draft of Kerala of Organized Crime Act. According to this piece of legislation, a confession made before a police officer with a higher level than of a superintendent police will be considered as evidence against the individual who made the confession. Therefore, it can be seen that under this section, a confession made to a police officer is not admissible in the eye of the law and cannot be proof against the person who made that. So moving on to the Section 26, it stated that no confession made by any person while he is in the custody of police officer, unless it be made in the immediate presence of a magistrate, shall be proof as against such person. Section 26 is based upon the same fear that the police will torture the accused and force him to confess either to the police officer himself. However, this section recognizes one exception, which is if the confession takes place in police custody but in immediate presence of magistrate, it will be considered valid and admissible. The rationale behind this is that the presence of a magistrate rules out the possibility of torture, thereby making the confession voluntary. Lastly, in Section 27 of the Indian Evidence Act, it stated that if the accused make a confession, it may be utilized to prove a fact or uncover additional facts during the investigation. There are also relationships between Section 27 and Section 25 of the Indian Evidence Acts. In Section 27, it describes the part of the confession which is self-incriminatory and only takes into account the part which leads to the discovery of new fact. However, the court said otherwise in the case of Pakala Narayana and Emperor. Section 27 does not allow the admissibility of statement made to a police officer in an investigation. It makes statement made to anyone except police officer admissible, such as visitor, doctor, and prison mate. Section 27 newly acts as a provision to Section 25 to lead to the discovery of new fact in case in order to move on further in investigation, and the part of the discovery must use as a new fact in the case. That's all from me. Thank you.
Next, I will proceed with the relevancy and admissibility of confessions under police custody in UK. So the relevant provision is Section 76, subsection 2, paragraph A of Police Criminal Evidence Act 1984, whereby it was stated that a confession must not have begun via operations in order to be acceptable. Torture, cruel or humiliating treatment, and the use or threat of violence are all examples of operations as in accordance to Section 76, subsection 8 of PACE. In general, the notions of operations appear to apply only when someone has authority, power or influence over the accused or persons in authority. Next, the operation must be intentional. Finally, it should be stressed that every intentional immorality amounts to operations. Next is the reliability test. Under this test, the question is whether whatever was said or done during the confession was likely to have rendered such confession unreliable. So by applying Section 76, subsection 2, paragraph B, a trial judge must examine all the relevant circumstances of interrogations before and after what was said or done and consider the nature and effect of what was said or done, the seriousness of the offence in question, and the terms of the confessions, which may throw light on the fact concerning the interrogations. The prosecutions also must demonstrate that the confession was not acquired as a result of anything said or done by someone in authority. In DPP and Pingling 1976, the police officer stated to the accused that if you show the court that you helped the police track down bigger drugs dealers, I'm sure he'll keep that in mind when he punish you. The accused revealed the identity of his source, and the House of Lords ruled that the accused's testimony was voluntary since no threat or enticement was made before he confessed. Lastly is Section 78, subsection 1 of the Police Criminal Evidence Act 1984. The basic point of Section 78, subsection 1 is that if confessions are obtained unlawfully or incorrectly, they may be dismissed as evidence in court. For example, in R and Paris, in this case, the accused made a series of confessions throughout the 13 hours interrogation session that amounted to a full confession of his culpability in the heist. When he testified before the jury, he stated that he knew nothing about the heist and that during the questioning, the police officer just made up answers to their own questions and invented that the admissions that he was purported to have made. He had refused to sign the interview notes. The court determined that the evidence would be used unjustly and hence omitted it. Thank you.
Now, let us make a comparative analysis between the Malaysian and Indian and the United Kingdom in respect of the evidence law of the admissibility of confession made in police custody. Here, we have a few similarities and also differences. First, there is a presumption of police in their line of duty would become prejudiced and abuses their power in violating the rights of the accused in order to obtain their confessions. Hence, such provisions exist to prevent practice of torture, extortion, and also oppression. Second, Section 25 of the Indian Evidence Act, Section 76 and 78 of the Police and Criminal Evidence Act, and also Section 25 of our Malaysian Evidence Act have a set of rigid prerequisites that needs to be fulfilled for confessions to be accepted as legitimate evidence. And the last similarities is that both Section 25 of the Indian Evidence Act and also the Malaysian Evidence Act accepts the admissibility of confessions made in police custody provided that there is an immediate presence of a magistrate or a sessions court judge. Now, let us look on their differences. In the United Kingdom, it stresses out the importance of voluntary confessions, regardless of whether it is done in police custody or not. What is important here is only the reliability of the confessions. While in India and also Malaysia, the law only stresses out that a confession made while in police custody or to a police officer is inadmissible. However, although Section 25 of both the Evidence Act of Malaysia and India is quite similar, the differences is that in the Malaysian jurisdiction, it specifies that only a confession made to a police officer of a specific rank, such as an inspector or above it, can be admitted as evidence, while in the Indian jurisdiction, it prohibits the admissibility of confessions made to a police officer regardless of any rank. Hence, we have two recommendations to make. First, amend Section 25 of the Evidence Act to follow the approach of Indian's Evidence Act. That means we get rid of the requirement of the admissibility of confession made to a police officer of a specific rank. We get rid of that. The second one is that police officer disclosing that a confession as a material factor in mitigation to the accused. Thank you.